You are welcome to the continuation of this series on defenses to criminal liability. We have examined the general principles that governs defenses to criminal liability, predicated on the plea of justification and excuse. Then we went on to look at the plea of self-defense. We looked at the conditions that must exist before a defendant can successfully rely on the plea of self-defense. Thereafter, we examine the defense of intoxication. We examine the defense of involuntary intoxication, the defense of voluntary intoxication, and then we looked at intoxication as a factor that may negate the existence of the subjective mental element that may be required by the law for an offense. Today, we want to continue in the series by having defenses to criminal liability part 5. In this particular presentation, we'll be looking at the defense of insanity. So I will share my slides in a minute so that you'll be able to follow the presentation. So in this presentation, like I've said, we'll be looking at the defense of insanity, and we look at insanity at the moment of the act of omission. We'll look at the disability and the loss of capacity. And in another presentation, we'll look at non-insane delusion. So what are the learning objectives, the learning objective and the learning outcome for this particular presentation? At the end of the presentation for the learning objective, the student should be able to understand the statutory provisions and judicial authorities governing the defense of insanity. What is the learning outcome? At the end of the lesson, students should be able to explain and apply statutory provisions and judicial authorities governing the defense of insanity. So we expect that when you have listened to this presentation, you should be able to explain and apply the statutory provisions and judicial authorities governing the defense of insanity. Now, the first aspect of the defense of insanity that we'll look at today is insanity at the moment of the act or omission. The defense of insanity demonstrates one of the hallmarks of excusatory defenses: the existence of a disability causing an existing condition, which makes the defendant not a fully free and responsible agent. If you remember, when we were looking at general principles governing excusatory defenses, we said that one of the hallmarks is that there is a disability, there's an existing disability suffered by the claimant or the defendant. And this disability causes an existing condition. And the effect of that condition is that the defendant is not a fully free and responsible agent. In other words, the disability and the existing condition makes the defendant to suffer from a disability condition, which renders him not fully free and responsible for his action. And if he's not fully free and responsible for his action, the law takes it that it will not be right to punish the defendant for the consequences of his act. And therefore, the defense steps in to excuse the conduct of the defendant. Now, the disability under the first paragraph of Section 28, the governing provision on defense of insanity under the provisions of the Criminal Code is Section 28. And the disability under the first paragraph of Section 28 of the Criminal Code is a state of mental disease or natural mental infirmity. So the disability is described as a state of mental disease or natural mental infirmity. As we go on, we'll come to look closely at the meaning of these phrases that constitutes the disability. The disability must have produced loss of capacity of the offender to understand what he is doing, to control his action, or to know that he ought not to do the act or make the omission. Again, we'll, in the course of this lecture, closely examine the effect of the disability, because it is one thing to establish the disability. The second thing is to establish the effect of the disability. The disability must have resulted in a loss of capacity of the offender to do either of the three things set out. Number one, to understand what he's doing. Number two, or to control his actions. Or number three, or to know that he ought not to do the act or make the omission. Now, the equivalent provision governing the defense of insanity under the Penal Code is Section 51. And the disability under the Criminal Code is described as unsoundness of mind. Unsoundness of mind. And the unsoundness of mind must have produced incapacity in the offender to know the nature of the act, or that the act is either wrong or contrary to law. So that is a loss of, that's how the loss of capacity is phrased under the provisions of the Penal Code. The disability and the existing condition must both have occurred at the time the offense was committed for the plea of insanity under both codes to apply. So what we are saying here is that the disability which causes an existing condition must have occurred at the time the offense was committed for the plea of insanity to be available to the defendant. So the critical point is, when the offense was committed, was the offender laboring under a disability which causes an existing condition that made him to lose any of the capacities set out in Section 28 of the Criminal Code and Section 51 of the Penal Code. So the relevant time is a time at which the offense was committed. It is not at the time of trial. If the offender is insane at the time of the offense of trial, that is not relevant for the purpose of criminal liability. What is relevant for the purpose of criminal liability is insanity, disability, and existing condition at the time the offense was committed. Now, so if at the time the offense was committed, the offender was not suffering from any disability, then he will not be entitled to the defense of insanity. And of course, we know that even people who suffer from mental incapacities sometimes have what they call lucid moments. So if he committed the offense during a lucid moment, during a time when he was not suffering from any disability, then the defense of insanity will not apply. So the defense must, the disability and the existing condition must have occurred at the time the offense was committed for the plea of insanity under both codes to apply. And then, as a general rule, we also need to know that Section 27 of the Criminal Code, provides for a presumption of sanity. The law is that a person is presumed to be sane at all times, and at the time, and particularly at the time when an offense was committed. So if the defendant is saying that he was suffering from insanity at the time the offense was committed, in order to displace this presumption of sanity, the onus is on the defendant pleading insanity to produce credible evidence of insanity. Now, this is one of the exceptions under the law, where the law puts a burden on the defendant to introduce evidence to support a plea that the defendant is relying upon. So you can see the case of Adamo and the State, 2014-10 NWLR, part 1416 at page 441. A defense of insanity connotes that the defendant committed the offense, but there was no intention or mens rea on his part. Yes, because as at the time he committed the offense, he was laboring under a disability which causes an existing condition that makes it impossible for him to act freely, that makes it impossible for him to be in control of his capacities, that made it impossible for him to control his capacity. So it connotes that the defendant committed the offense, but there was no intention of mens rea. The consequence of a successful plea of insanity is a verdict of not guilty by reason of insanity. So where the court finds that the defendant has successfully established a plea of insanity, the court will enter a verdict. The court will make a decision that the defendant is not guilty by reason of insanity. You can see the case of R. and Ashi Gifu, 1984, 12 Waka at page 389. The consequence of that conviction is that the defendant is committed to a mental health asylum or prison at the pleasure of the governor of the state where the offense is committed until medically certified to be sane. Now, the offender is not an offender with respect to whom the court has entered a verdict of not guilty by reason of insanity is not being punished. The only reason why he's confined in a mental health asylum, which is where he ought to be confined and not a prison, is that there is need to protect the larger society from the defendant who has been found not guilty by reason of insanity. Because if he's still laboring under the disability that caused that existing condition under which he committed the offense, then there's a possibility that he may commit further offenses. And there's a need to protect the society from any other violent conduct that the defendant may be disposed to committing. So he's committed in a mental health asylum where medical people would take care of him, and some of the, insanity in certain circumstances may be curable. Now, if it's found to have been cured over a period of time, then he may be released and set free from a mental health asylum. Otherwise, he will continue to be kept in a mental health asylum until medically certified to be sane. That is pursuant to the provisions of the Administration of Criminal Justice Law. That is ACJL there. And you also find similar provisions under the Administration of the Criminal Justice Act, which is a federal legislation. The second paragraph of Section 28 of the Criminal Code also provides for the defense of non-insane delusion. In the next presentation, we'll be able to examine non-insane delusion. Now, we have been looking at general issues relating to the defense of insanity. We looked at the fact that insanity must be at the moment of the commission of the offense. We looked at what constitutes insanity under both the criminal code and the penal code. And we looked at what constitutes the disability and the loss of capacities, and the fact that there's a general presumption of sanity which puts a burden on a person raising a plea of self-defense to introduce evidence, credible evidence, to establish his plea, and so on and so forth. Now, we want to look at the legal elements of the defense. So a defendant who seeks to rely on the plea of insanity must establish the legal elements of the plea, or what we sometimes call the ingredients of the defense. Now, the first one that we're going to look at is the disability. What is the disability? What constitutes the disability? How is the disability described? That's what we are going to be looking now. Now, before we look at the provisions of the criminal code and the penal code, we want to see how the concept of disability evolved under the English law. Now, under English law, the famous McNaughton case, that was a case that was decided in 1843. It was in that case that a first attempt to formulate rules that relieves of criminal responsibility on the grounds of mental disorder was made. The case formulated the rules that relieves of criminal responsibility on the grounds of mental disorder. And the rules were formulated as follows. One, excuse me. Everyone is presumed sane until the contrary is proved. So there is also this presumption of insanity under English law. Now, it is a defense for an offender to show that he was laboring under such defect of reason due to a disease of the mind. That is the description of the disability condition under English law. Defect of reason due to a disease of the mind. And the loss of capacities were outlined in the McNaughton case as follows. As either A, now the defect of reason due to a disease of the mind produce the following result in the offender. Loss of capacity to know the nature and the quality of his act. In other words, as a result of the defect of reason due to a disease of the mind, he does not know the nature and the quality of his act. Or if he did know this, not to know that he was doing what is wrong. That is a loss of capacity that the defect of reason due to a disease of the mind must have produced in the offender. So that is how the disability and the loss of capacity is couched under English law. Now, the phraseology of the disability condition under the McNaughton rule has been, a subject of criticisms over the years. And one of the major criticisms of the rule identified by Okonkwo and Nash is the view of psychiatrists who pointed out that there are many mentally ill people who, though able to appreciate intellectually that an action might be wrong, nevertheless were under intolerable emotional pressure to commit it. In other words, they are able to realize that what they are about, to do may be wrong, but something is putting them under pressure as a result of defect of reason due to a disease of the mind. They are under pressure to go and do the crime. Some of them will say that they are hearing voices commanding them to go and do the wrongful act, even though they know that what the voice is asking them to do is wrong. But the voice keeps on ringing in their ear. Now, that, in view of psychiatrists, should relieve of criminal responsibility on the grounds of insanity. But under the McNaughton rule, that does not qualify as one of the loss of capacities, because incapacity to control action is not identified in the McNaughton rule as one of the instances of loss of capacity. So that's one major criticism that have been made over the years against the rule, the McNaughton rule. Now, the disability under the McNaughton rule was that the defendant was laboring under such defect of reason due to a disease of the mind that impaired his capacity not to know the nature and the quality of his act, or if he did know this, not to know that he was doing wrong. Now, the disability is described as a state of mental disease or natural mental infirmity under the criminal code. We have seen this earlier. Under section 28 of the criminal code, the disability is described as a state of mental disease or natural mental infirmity. Okonkwo and Nash suggested that mental disease should be construed to mean disease or disturbance and should cover many different types of mental abnormalities. There are many different types of mental abnormalities, known to medical people. The court bearing in mind significance of the particular abnormality and the extent to which it has impaired capacity. So, according to Okonkwo and Nash, mental disease should be construed to mean disease or disturbance that should cover many types of mental abnormalities. There are many types of mental abnormalities. Depression is one, schizophrenia is one, psychosis is one, and there are different medical terminologies that have been used to describe different types of mental abnormalities. But what is important is not really how those mental abnormalities are described, but whether those mental abnormalities has produced a loss of capacity in the offender to come within the definition of loss of capacities under the provisions of the criminal code or under the provisions of the penal code. Now, the criminal law of Lagos State has replaced the phrase mental disease or natural mental infirmity with mental disorder. Now, this was an attempt to respond to some of the earlier criticisms, leveled against the McNaughton rules, because the medical practitioners feel disconnected from the phraseology of the disability, under the McNaughton rules. And the criminal law of Lagos State adopted, a phraseology that medical people are much more, find it easier to relate with. And that's why the term mental disorder, they can easily relate with mental disorder, a term such as mental disorder, rather than, the rather vague term mental disease or natural mental infirmity. So the phrase mental disorder is a simpler term which should cover different types of mental abnormalities. Again, mental disorder will also cover different types of mental abnormalities. Once it can be shown that it's a condition that affects the mental capacity of the offender and also is capable of resulting in the loss of capacity as defined by the provisions of the criminal law. In Adamu and the state, the Supreme Court stated that insanity is a blanket term. It's a very wide term, embracing a considerable variety of mental abnormalities, mental infirmities, neuroses, and psychosis. So it's a very, very broad term, and it's broad enough to cover a considerable variety of mental abnormalities, mental infirmities, neuroses, psychosis, schizophrenia, and various other types of mental abnormalities. So we should not be discouraged by the rather ambiguous term mental disease or natural mental infirmity. The court has said, look, these terms, are wide enough to embrace a number of mental abnormalities, mental infirmities, neuroses, and psychosis. These are terms that mental people terms that medical people are quite familiar with, and they're able to explain how these actually play a role in affecting the mental capacity of the offender. Now, the alternate leg under the criminal code to mental disease is natural mental infirmity. And this was defined in R. and Umoni, 1949, 12 Waka, page 311, by the court to mean a defect in mental power. A defect in mental power, neither produced by his own default, nor the result of disease of the mind. So what the court is saying here is that the alternate term of disability under the criminal code, which is mental disease or natural mental, the alternate term under the criminal code, which is natural mental infirmity, means a defect in mental power. So whatever causes in the defendant a defect in mental power, the offender is not able to operate at the normal level, of mental capacity or mental control. And that defect or inability to operate at the normal level of mental capacity is not produced by his own default. In other words, it's not something that he brought upon himself. Okay, it's not a defect in mental power, an inability in mental power that he brought on himself by his own default, or the result of the disease of the mind. Of course, we've already said mental disease. So that's a clear, mental disease is one clear leg of disability. And the court in Arumoni is saying that natural mental infirmity means a defect in mental power. A defect is like a lowering or a diminution, a reduction in mental power, a reduction in mental capacity, a reduction in mental functioning that is neither produced by his own default. In other words, that reduction in mental functioning is not produced by the conduct, it is not produced by the defendant's own fault. So if he creates a situation or if he brings himself into a situation that leads to a reduction in mental functioning, then that is not natural mental infirmity for the purpose of the law of insanity, or not the result. So, and it cannot be a result of the disease of the mind. Okay, it cannot be as a result of mental disease, which is already covered in the first leg. And the court adopted the meaning of natural mental infirmity propounded by the court in Ara and Omoni was actually a meaning propounded by Stevie in Stevens' Digest of Criminal Law. So the court adopted it for the purpose of expounding the term natural mental infirmity for the purpose of the second leg of disability under Section 28 of the Criminal Code. The definition in Ara and Omoni was adopted in Ara and Tabige, and the court added that the meaning of mental defect may also be sought from the English Mental Deficiency Acts of 1913 to 1938. Section 5 of the 1938 Act defined mental defectiveness as a condition of arrested or incomplete development of mind existing before the age of 18 years, whether arising from inherent causes or induced by disease or injury. So the court said that the meaning of the term mental defect, because the essence of this one in Ara and Omoni is to, give a meaning of mental defect. And the court said that the meaning may also be drawn from the English legislation on Mental Deficiency Act, which defined mental defectiveness as a condition of arrested or incomplete development of mind existing before the age of 18 years. So this is a medical condition under which a person's development of mind is arrested or incomplete. The person's mind is not completely developed, and this condition may exist in some people, before the age of 18 years. Now, in our Meru, 1959 Western Region of Nigerian Law Report, the court rejected the defense of insanity and held that the infirmity disclosed was not a natural mental infirmity, and it was induced by the defendant's worship of juju and or witchcraft. Okay, in that case, the defendant was trying to make a plea that he committed the crime based on the fact that he was obliged to do so by his belief in witchcraft. And the court rejected that defense and held that the infirmity disclosed was not natural. It was brought about by the defendant's own belief of the defendant's worship of juju and of witchcraft. Okonkwo and Nash has argued that while the decision is right, the reasoning given for the decision is not quite right. And according to them, what the court should have ruled was that the defendant was not able to show that witchcraft produced, in him a state of mental defectiveness, affected him, caused him to suffer from a state of mental defectiveness as to make him to lose any of the capacities provided by the law. So it's not just enough for somebody to raise a plea of insanity based on witchcraft or juju. The infirmity, the worship of juju or belief in witchcraft must have produced a state of mental defectiveness, which resulted in loss of capacity. So the question should have been whether the belief in witchcraft has impaired the defendant's mental faculty. In other words, has the belief in witchcraft produced a mental defectiveness that has resulted in a loss of capacity? If it has, then maybe the court can then consider whether that is a sufficient basis for the plea of insanity to succeed. Whether a defendant is suffering from a disability condition and loss of capacity is a question of fact. And the burden is on the defense to establish the defense. So it's always a question of fact. The court will look at the evidence, you know, and just like you may also be confronted with different factual scenario in a problem question. Now, your responsibility will be to apply the legal elements of the offense and relate it to whether from the facts there is evidence to suggest that that disability condition the offender is suffering from has resulted in a loss of capacity. And by the time we look closely at the loss of capacity, you will see the various ways in which the loss of capacity can manifest. And the burden of doing this is on the defense. In the absence of evidence to support the disability condition, the court will not be able to assess whether it is such as will have impaired the mental faculty of the defendant. So if the defendant is not able to, you know, lead any evidence to support the disability condition, then the court will not be able to assess whether the disability condition has impaired the mental faculty of the defendant. So it's important for the defendant, number one, to lead evidence to establish the disability condition. And then to also show that that loss of disability, that disability condition has resulted in loss of capacity. You can see the case of Willie and the state. In Edo and the state 2010-14 Nigerian Weekly Law Report, part 1214, 1214 at page 651, where the court rejected the defense of insanity pleaded by the defendant, the Supreme Court made the following important remark about reliance on witchcraft and insanity. That's par Ogwagu JSC. The court stated that as follows. However, a defense founded on belief of witchcraft or juju is a defense that is untenable because it is a defense founded on the subjective belief of the accused person, rather than on the objective requirement of the law relating to the particular relevant defense. Now, the next statement by the court is very important. But if the belief in witchcraft or juju produces a state of insanity or delusion, then the criminal responsibility of the accused person will be measured not by the tenets of his belief, but by the objective standard of the law relating to such defense, viz., insanity, delusion, or provocation. Now, what the court is saying is this. If a defendant claims that because of witchcraft, he was laboring under a witchcraft spell that made him to kill the victim. Now, the court said that that's a belief in witchcraft, which is untenable. But if the defendant is able to show that that belief in witchcraft produces a state of insanity, in other words, if it leads to, for instance, natural mental infirmity, if it leads to a defective mental state, in other words, if he's able to show that he so much believed in that witchcraft that the thing has now created a reduced mental capacity for him to function in a normal, for him to function with full mental capacity, the way a normal human being will have functioned. And that defective mental state has produced a loss of capacity, which is the requirement of the law of insanity, then the court will consider it and apply the rules to see whether that is sufficient to avail the defendant of the plea of insanity or of any of the other pleas, or the plea of delusion or provocation, as the case may be. Now, the penal code in section 51 use the term unsoundness of mind. So the phrase used under the penal code, remember we are still looking at the disability condition. The phrase used under the penal code to describe the disability condition is unsoundness of mind. The criminal code use the phrase mental disease or natural mental deformity, or natural mental infirmity, while the penal code is using the term unsoundness of mind to describe the disability condition. And This term, although has been described as vague, it has been commended because it is wider in scope or soundness of mind. It is wider in scope and can be employed to cover all cases of mental abnormality, recognized disorder, or derangement of understanding. According to Professor Chuko, he says that the term unsoundness of mind is wider in scope and can cover all cases of mental abnormality, recognized disorder, or derangement of understanding. In determining the meaning of unsoundness of mind, the courts have approached the issues as if it means the same thing as mental disease or natural mental infirmity under the criminal code. So the point being made is that when the court is considering the meaning of unsoundness of mind under section 51 of the penal code, the courts have approached the issue as if it means the same thing as the disability condition under the criminal code, mental disease or natural mental infirmity. And you can see the cases of Mohammed versus Kano State, 1214, 4 NWLR, part 1397 at page 320, and also John versus the State, 2012, 7 Nigerian Weekly Law Report at page 1299, part 1299 at page 336. Now, we want to closely examine the loss of capacities. So after the defendant has been able to bring himself within the disability condition, then he must also be able to establish the loss of capacity. It is not enough that the defendant suffered from mental disease or natural mental infirmity, or as the penal code provides, or soundness of mind at the time of the commission of the offense. The disability must have produced a loss of capacity of the offender to understand what he is doing. That's section 28 of the criminal code. Or know the nature of the act, section 51 of the penal code. Then the second one, loss of capacity of the offender to control his action. This leg of loss of capacity is only provided for under the criminal code. And this leg is also not provided for under the McNaughton rule. So this leg of incapacity to control action is unique to the provisions of the criminal code. And then the third leg of loss of capacity, to know that he ought not to do the act or make the omission, section 28 of the criminal code, or to know that he is doing what is either wrong or contrary to law, section 51 of the criminal code, section 51 of the penal code. Now, loss of capacity, continuation. Now, you need to see section 27.2 of the Criminal Law of Lagos State, 2011, which tries to provide, to give a meaning of what constitutes capacity. Now, we're not going to look at each leg, excuse me, each leg of the capacity in greater detail. Capacity to understand what he's doing, or capacity to know the nature of the act. Okonkwo and Nash has suggested that the word understand has a wider connotation than the word know. While this may be true in the specific example, it is my view that the courts may construe knowing under the penal code to include understanding. Because how can a person be said to know the nature of his act if he does not fully understand what he is doing? So the first leg is capacity to understand what he is doing, or capacity to know the nature of his act. To understand what he's doing is under the criminal code. To know the nature of the act is under the penal code. Capacity to control his action. Like I've said earlier, this leg of loss of capacity is only provided for under the provisions of the criminal code. There's no equivalent provision under the penal code. In Aranomoni, the West African Court of Appeal noted that this provision allows a defense of acting under irresistible and uncontrollable impulse. So a defendant may understand what he is doing, but he may be under such an irresistible and uncontrollable impulse. For instance, he may be hearing a voice very loud in his brain as a result of his mental disease or soundness of mind, commanding him, go and kill this person, go and kill this person. If he lies down, he's hearing the voice. If he stands up, he's hearing the voice. So in order to free himself from that irresistible and uncontrollable impulse, he may go ahead and kill the victim. Now, in HM&R, the plea of insanity on the basis that the defendant was incapable of controlling his actions succeeded. The court acted on medical evidence of a head injury sustained by the defendant, which the doctor said could make him know what he was doing, but could render him incapable of controlling his action. So here, there was medical evidence to support his claim, because it's very easy for a defendant to say, yes, I was hearing a voice, or I was suffering from a condition that, that I could not resist. Because it's up, the evaluation of that will entirely be up to the evidence he gives, and the court may be a little bit suspicious on relying only on the testimony of the defendant. But in this particular case, there was medical evidence which supported the claim that the defendant was incapable of controlling his action. The doctor gave evidence that the kind of head injury he sustained was such that although he could know that what he was doing was wrong, but he was incapable of controlling his action. Then the third leg of capacity under the criminal code, capacity to know and the equivalent provision under the penal code. Capacity to know that he ought not to do the act or make the omission. That's under the criminal code. Or that is doing what is either wrong or contrary to law. Now, where there is evidence that the defendant knew that what he did was wrong, that should be evidence that he knew that he ought not to do the act or make the omission. The penal code provision contains, in addition to the word wrong, the alternative leg of contrary to law. A man who kills another believing that his act is wrong, yet induced by insanity to believe that it is not contrary to law, will have a defense under Section 51 of the Penal Code, because Section 51 contains the alternate leg of either wrong or contrary to law. Okonkwo and Nash suggest that the criminal code should be construed to require that the offender knows that the act is wrong or contrary to law, citing the provisions of Section 229 of the Criminal Procedure Act. Now, in Ado versus the state, 2021 12 Nigerian Weekly Law Report, part 1791, at page 427, the Supreme Court held that the court should consider the following circumstances where a plea of insanity is raised. Now, all these circumstances that the court noted here relates to loss of capacity. A, whether there was preparation for the act. Whether there was preparation for the act. So if there is evidence that the offender took great care in preparing for the offense that he has committed, maybe, for instance, he took great care to find out when the victim, to find out about the victim's itinerary for the day in which he wanted to strike, took meticulous care to make sure that there will be no eyewitnesses around, make sure that he came at a time when all his children and all his neighbors would not be around, took a lot of time to prepare for the act. What do you think that this will suggest? This will suggest that he knew that he ought not to do the act or make the omission, or that what he was about to do is wrong. Now, B, whether it was done in a manner that showed a desire for concealment. Maybe after committing the act, maybe he shot the victim and he now went to go and hide the murder weapon, either a cutlass or a gun. He went to go and bury it somewhere. That showed a desire for concealment. What does that suggest? That suggests a guilty mind. That suggests that he knew that what he did was wrong, meaning that he had not lost his capacity at the time he committed the act. C, after the crime, the offender shows consciousness of guilt and made efforts to avoid detection. Maybe after breaking into the house of the victim at night and killing the victim, he made sure that he did not leave any trace evidence behind. He went with he wore hand gloves to make sure he did not leave any fingerprint on the door or on any item in the deceased home. So he showed consciousness of guilt and made efforts to avoid the detection. And after the crime, the offender offered false excuses and made false statements, all trying to hide the fact that he committed the offense. Now, all these circumstances will show that he had the relevant capacity. And this is very critical. When you are dealing with a problem question in the exam, and that problem question raises the issue of insanity. Now, of course, we expect you to make reference to the relevant provisions under Section 28 of the Criminal Code, under Section 51 of the Criminal Code, to identify disability, what constitutes the disability, to explain what constitutes a disability, mental disease or natural mental infirmity, to give us some of the cases explaining what all this means, on soundness of mind under Section 51 of the Penal Code, and then to go on to discuss the loss of capacities and the various instances. And then we expect you to now carefully relate particularly the loss of capacity to the problem question that you have, because it is at that point that you'll be able to resolve the problem question correctly, and your analysis will lead to a logical conclusion. So this case of Ado and the state is very, very critical, because if the defendant is able to establish the disability, that's the first leg. Now, the second leg for the successful plea of insanity is to be able to show that the disability has produced a loss of either the capacities provided, either the three capacities provided under Section 28 of the Criminal Code or Section 51 of the Penal Code. So we will stop this presentation here. In another presentation, we look at non-insane delusion. So I expect you to listen to this presentation carefully and come prepared to class with your questions concerning any aspect. And also, if you need any further explanation on any of the items, on any of the cases, we will have sufficient time in class to be able to do so. Don't forget to subscribe to this YouTube channel, so that as I post subsequent presentations, you will get a notification, and that will give you ample opportunity to be able to listen to the lecture and come prepared to class with your questions, so that we can both examine those together and throw greater illumination into the presentation. Thank you very much for your attention. God bless you.